Okay. أحس بشي وايد.
My hair.
So, are you ready?
I'm ready.
يلا, let's start.
go.
Let's go.
So this week, Omar, is Dubai Arbitration Week, and we thought it would be a good opportunity to discuss some recent cases in the arbitration field, and also to discuss the way that the courts are recognizing and enforcing arbitration awards more generally.
Yeah.
So before we start, it might be useful to point out that in the UAE there are 3 types of arbitration awards. The first is a domestic award, and that's a situation where the UAE federal arbitration law is governing the arbitration and the award. The second is an offshore award, which is an ADGM or a DIFC award, and in that case the DIFC arbitration law or the ADGM arbitration regulations are applicable. And the third is a foreign award, where a foreign arbitration law will apply to the award and the arbitration itself. Maybe we could start with just talking about how the UAE courts are treating domestic arbitration awards at the moment, and the procedure for recognizing and enforcing a domestic arbitration award in the UAE courts.
I think, Zarghona, first of all, we need to know how to differentiate between the domestic arbitration award and offshore award and foreign arbitration award. I think the seat of arbitration will determine the classification of such award. So if the seat of arbitration, for example, Dubai or Abu Dhabi or Sharjah, and the governing law is the arbitration law, then the domestic court will have the authority or the jurisdiction to enforce and to set aside the arbitration award. And correct me if I'm wrong. If the DIFC or ADGM is the seat of the arbitration, then the DIFC court or the ADGM court will have the jurisdiction to set aside and or to enforce the arbitration award.
That's right. I'll just interrupt there just to point out in terms of the seat will dictate which court can set aside the award, but it will not necessarily dictate which court can recognize the award.
So you can enforce it in any court.
Right, subject to the jurisdiction's arbitration
and subject to where the assets of the other party located.
Yes.
So when it comes to recognition and enforcement of the arbitration award, if it's a domestic arbitration award, you have to file an application to the Chief Justice of Appeal Court in the Emirates where you want to execute the domestic award. You have to submit with your application a copy of the arbitration award. If it's in English, of course, you need to translate it. A copy of the arbitration clause, and what else? The minutes of the hearing confirming that the arbitration award is submitted to the Chief Justice. Then the Chief Justice or his delegate will have around 60 days by law to issue the enforcement or recognition order to recognize and to enforce the arbitration or the domestic arbitration award. The other party can file an objection on such order, or the applicant, if the Chief Justice or his delegate rejected the application, file an objection to the appeal court to decide on such objection. The other party can, of course, file a set-aside case to nullify the arbitration award during 30 days after the service of the arbitration award. The grounds of setting aside the arbitration award already specified in Article 53 of the arbitration law. In general, if there is any ground related to the arbitration clause itself, for example, if the clause is null or who signed the arbitration clause doesn't have authority, the other ground is the applicable law. So if the tribunal apply a law where the party or which the party didn't agree to have such law as the governing law of the contract or the arbitration, then you can rely on such ground to nullify or to set aside the arbitration award. A ground related to the public policy.
Right.
For example, if the tribunal issue or render their award after the frame, the time frame which they should issue the arbitration award therein. So these kind of grounds actually shows how the law provide a bit strict test to nullify or to set aside the arbitration clause. And to be honest with you, based on our experience, it's so difficult to set aside an arbitration award nowadays.
Yeah, which is different from, say, 5 or 6 years ago,
Yeah,
before
of course.
the new arbitration law was enacted.
Yeah.
But there are still some peculiarities or formalities which, still need to be complied with in order to, sort of reduce the risk of having the award set aside.
Mm-hmm.
For example, we previously had issues with signatures by the arbitrators on each page, and it wasn't clear when the new arbitration law came into effect whether that had been done away with or whether we still needed to comply with those formalities. I think what we have seen is you still need to sign the arbitration award on every page, but correct me if I'm wrong.
I think so, yeah, it's correct. But the arbitration law provides the party with a new mechanism to rectify such formalities. So if there is any formal defects, I can say it, if it's defects is the right word to say that.
Yeah.
So if there is any defects related to formality of the arbitration award,
they can send it back to the arbitrator.
you can ask or request the court to send the award back to the arbitrator to rectify it.
Right.
And to remove or to rectify it, and that's it. Yeah.
Which is something that wasn't there before.
Yes.
Which is very welcomed. But and you and I have done a case dealing with this before. There's there was an assumption amongst many of the arbitration community, or many within the arbitration community, that you didn't need to do this for foreign seated arbitrations, but we've seen that there are court cases, or there is at least one court case in which the court refused to recognize a foreign seated arbitration award because it had not been signed on every page.
Yes.
So from a foreign arbitration perspective, or foreign seated arbitration perspective, we would now recommend that you comply with that formality and you ask your arbitrator during the arbitration to sign the award on every page, wouldn't we?
Yeah, because the mechanism which I explained about rectifying the issue related to the formalities, it's only applicable to domestic arbitration awards, not foreign awards. So again, it's really advisable to request the tribunal who handle any foreign seated arbitration or foreign or international arbitration proceedings to sign each pages of the arbitration award.
Right, and we'll get into the mechanism for enforcing foreign-seated awards, which are different, as you say, to domestic awards. And as you say, for that reason, there is no opportunity or mechanism for the court to send it back to the tribunal.
You know why? Because the law which govern enforcing the domestic arbitration awards is the arbitration law.
Yes.
But when it comes to the foreign or international arbitration award, you have to rely on the procedural law. With respect to enforcing the international arbitration award, you have to apply to the execution judge, not to the Chief Justice of Appeal Court.
Yes.
And with your application, you have to attach a copy of the arbitration award, a copy of the arbitration agreement or the clause. If the arbitration is done through any arbitration center, a letter from such center actually important to file with your application to show that the award is final, the other party has been served with the proceedings.
It does pose the question because the law says that you have to, you can recognize and enforce foreign awards and judgments in this case in the event that certain factors have been satisfied. And one is that the award or judgment is final and enforceable. And as you say, the way that we have been doing that is to ask the arbitration centre for a letter confirming that the award is final and enforceable. But then in circumstances where there is no arbitration centre involved and it's an ad hoc arbitration, it does pose a question of how you would satisfy that requirement.
I think one way to satisfy such a requirement is to ask or request the tribunal, the ad hoc tribunal, to issue a letter confirming that the other party or the party has been served with the arbitration process, and such process is a final and binding, instead of having such letter from the center. But my question is, sometimes or some arbitrators believes that when they issue the arbitration award,
they're done.
It's done. So they have no authority to do anything else. So from the beginning,
there's a functus officio doctrine.
Yeah. So from the beginning, you can request the tribunal with issuing the arbitration award, to issue as well a letter confirming that such award, or in the award, they can mention that the party has been duly served, they submit their defense, and there are a mechanism. To be honest with you, most of the arbitration award that we enforces come from a center, arbitration center, such as ICC or LCIA.
And we've never had any issues with the arbitration center issuing the letter that we've requested. But I think it's important to bear in mind, if it's an ad hoc arbitration and you intend to enforce that award in the UAE, the procedural requirements in the UAE are that you have to show that the award is enforceable, and you also have to show that the other party participated in the proceedings. And often that can be addressed in the award itself, and often it is addressed in the award itself, where at the start the award clarifies who was present and which party was represented by which set of lawyers, etc. But it is something to bear in mind. And speaking about the capacity of the tribunal then to take any steps after issuing the award or rectifying the award, which lots of the rules provide for. Again, we come back to the signature point as well. Because we have had situations where after the UAE court issued its decision requiring a signature on each page, we had to go back to a well-known arbitration centre, and they helped us and facilitated the sending the award back to the tribunal and getting it signed on every page. But there have been cases where the arbitration institution or the tribunal has refused to do that on the basis that they don't have capacity to go and sign every page of the award after the fact. So, that's something we should bear in mind when we're getting the award.
I think when it comes to enforcing an arbitration award issued from a foreign country, the convention award will proceed. So the condition provided by the New York Convention will supersede the condition provided in the procedural law, as far as such award issued from one of the state party of such convention.
In theory, but in practice, and we've both had this experience, the court is actually relying upon often the formalities in the civil procedure law. And in practice, for example, we've had situations where the court has refused to recognize an award which was issued in another New York Convention state, such as England, on the basis that it doesn't have jurisdiction, whereas in theory, if you were simply complying with the New York Convention, the court should have recognized and enforced that award. I know you're familiar with the case I'm talking about.
Yes.
So whilst I appreciate that, I think theoretically that makes sense, but in practice, it's very important to be aware of these formalities, because in practice, what I've been seeing is that the court is not relying solely on the New York Convention, but is trying to apply these factors which are in the civil procedure law. So there are a couple of other things I just want to talk to you about briefly, and then these are other important arbitration cases that have been handed down over the last year or so. So the first case is a situation where the court has considered whether or not an arbitration clause is enforceable in circumstances where one of the parties has gone to arbitration and the other party has refused to pay their share of the advance on cost, and therefore the arbitration centre has dismissed the arbitration for that reason. And then the other party has come, the claimant has come to the court.
And the refusing party
and suddenly the party that refused to pay the advance on cost is relying upon the arbitration clause to argue that the court doesn't have any jurisdiction to hear that claim. For some time there was ambiguity around this issue.
Yes, there was,
as to whether or not the court would take jurisdiction, seize jurisdiction, or whether it would refuse to hear the case on the basis that there is an arbitration clause and the parties need to comply with that.
There were two views.
And
among, I'm talking about Dubai courts here. The first view is that if the party file an arbitration claim and the arbitration tribunal decided to dismiss the arbitration proceedings due to the fact that one of the party didn't pay the advance cost or anything related to cost, then the such dismissal will be considered as the end of the arbitration clause. So the arbitration clause will not remain exist. However, the second view is that in such scenario, because the tribunal didn't decide on the merit of the case. So the arbitration clause will remain exist
valid.
And valid.
But I think that issue has now been resolved, although there's no binding precedent in the courts here. We're relatively comfortable with the position that the court will not take jurisdiction in those circumstances and will ask the parties to go to arbitration. And that I think is very helpful. It provides some certainty. And another interesting case which has recently been handed down by the court is a decision where the court held that an arbitration clause in one agreement can be relied upon in subsequent agreements between the same parties.
And same nature.
And if you can expand upon that.
Actually, the condition in the judgment stated that different or several agreements chronologically come sequentially has same nature, same party. The first contract or the original contract contain an arbitration clause. The subsequent contracts do not have any dispute resolution mechanism. So the court then may enforce the arbitration or consider the arbitration clause in the first or the original contract and dismiss the case.
So the court will not take jurisdiction?
They will not take jurisdiction. I will just give you an example.
Provided you can satisfy.
An example, usually in the construction contract, you will have a contract, then after the contractor starts the execution of the project, so then the contractor will issue a new purchase orders. So one of the, in this case, the contractor says that the new purchase orders is not linked with the original contract and it's a separate contract, it doesn't have an arbitration clause, and then the court will have jurisdiction on such purchase
that,
orders.
yeah,
But the court said, no,
dispute.
it has the same nature. It comes after signing the original contract. It has one nature, one parties.
So the same arbitration
yes.
clause,
So they
is
consider the
applicable.
arbitration
Whether
clause.
or not the arbitral tribunal will find the same or reach the same conclusion is another matter. But,
Yes.
so, and one final case that I wanted to speak to you about is there are, or a couple of cases which we've seen, which whilst the cases we've discussed till now provide more certainty in arbitration, there are a couple of cases which we've seen in the Abu Dhabi court, which some would say have given rise to some uncertainty about the seat of Abu Dhabi seated arbitration
With ICC rules.
with ICC arbitration rules applicable, because there have been some cases where the Abu Dhabi court, a party has approached the Abu Dhabi court under the federal arbitration law to set aside an arbitration award, and the Abu Dhabi court has held that it doesn't have the jurisdiction to set aside the arbitration award, and has refused to hear the matter of its own volition, and has told the parties, or has handed down a judgment finding that the parties need to go, or it doesn't have jurisdiction because the ADGM has jurisdiction on the basis that the ICC arbitration rules have been applied to the arbitration. And the ICC, as we all know, has a representative office in the ADGM. We've experienced similar things in Dubai and with the DIFC LCIA, which I think that's been done away with now because there is no DIFC LCIA. Yes. But would you like to comment on the Abu Dhabi cases?
So in brief, my view about the judgment is that it's a matter of fact, and the court has grounds for issuing such judgment. But what would you advise based on such fact? What would you advise the lawyer when they draft the arbitration clause to avoid such uncertainty?
So if a party would like to have an Abu Dhabi seat for the arbitration, and would also like to have the arbitration governed by the ICC arbitration rules, one way to try and reduce the risk of the court, the Abu Dhabi court, refusing to seize jurisdiction in that case would be to make it clear when it says the clause states that the seat of the arbitration will be Abu Dhabi, perhaps in brackets include, but not ADGM. And I would hope that would try and reduce the risk. I mean,
we don't know whether
the other option is choose another set of rules. Yeah. If you want an Abu Dhabi seat, then choose another set of rules.
So it was a pleasure speaking to you, Zarghona, and discussing these topics.
The pleasure is all mine, and I look forward to touching on these topics and more at our presentation at Dubai Arbitration Week.
Oh, okay. Yeah, that's great. See you soon there.
See you soon.